So what we are covering today is the process of mediation, the principles of mediation, opening statement, and the simulation exercise we are going to do tomorrow. But we will basically understand what the exercise is, and we will do it tomorrow. Because for these three topics, I'm guessing that I'm going to take the entire time. So mediation is a process. And the mediator is the person who controls that process. Our job as mediators is to take the parties through a process through which we try and resolve the conflict. Remember that as a mediator, while our end goal is always resolving a conflict or finding a solution, for a mediator, it's primarily focusing on the process to be able to reach that solution. We don't, from the minute we start, we don't start looking at the solution, or we don't try to say, how is this problem going to get solved by coming up with solutions, but we focus on how to conduct every step of the process, eventually to reach a solution. So the aim of the process is to enable maximum participants of the disputants, to build trust and communication. We spoke about it yesterday, that here in this process, there are no lawyers who speak for the clients. It's the clients who speak for themselves and the lawyers support them. So there's kind of a role reversal where in a mediation process. In every other process, for example, arbitration or litigation, it's the lawyer who gets briefed by the party and the lawyer who represents the party's interests. The lawyer presents the case, defends the stand they take, and their whole approach is to prove a point. Whereas a mediator will ask the lawyer to support the party. Lawyers do have a role, and it's a very important role, but it's a role of ensuring that the interests of the party are met, not by speaking to the party, but basically empowering the party to speak for himself or herself. And therefore, the role of the mediator is to enable that participation from the disputants. Or again, the word disputants is not the right word, from the participants in the process. Build trust and communication, and move from people to problem. When people are in a conflict, they are focused on blaming it on somebody. When there's a problem, you will rarely say that this is the problem. You will mostly say, he has created this problem. He has an ego. He doesn't listen. He is the one who's at fault. So the blame is generally on the individual rather than trying to see what the real problem is or what actually went on. Your goal as a mediator is to move from this blame to the actual problem, to the fact. And from you versus me to us versus the problem. So they say that dialogue is the art of thinking together. So eventual goal of mediation is that the parties understand that they are facing a problem, which is not about somebody creating the problem and somebody, being hurt by it. It's about both of them looking at the problem and trying to say, how can we move forward? Identify and understand the problem, and facilitate parties to generate options to resolve the problem. Eventually, facilitate agreement, resolution, closure. Not all not all mediations reach a settlement or a resolution, but even those that don't need to be ended on a positive note. So that closure being such that people walk away not in as emotional a situation as they entered it is what we need to ensure. So the process has to actually diffuse the tension and allow them to communicate to each other, build some form of connection during the process. So that is the aim of the process. The process has 4 basic steps: introductions, communication, problem solving, and agreement or closure. Introductions has the purpose of building trust, of creating a safe space for people to be able to say what they want to say, of empowering parties to understand what they're going through. Many people who come through to mediation may not be aware exactly what is it that the process is. They're new to it. They may have heard that is a mediation and it's a method by which you don't have to go to court, or it is, it's a way you can come to a settlement, but they're not exactly aware what their role is, what the mediator does. So in fact, a lot of parties will address you as, your honor or my lord or things like that, and tell you, now you decide, you see who is right or wrong. So those kind of expectations they come with. So it's your job to kind of let them know what exactly is the process about, and also introduce each other, see how what people are comfortable in terms of what they like to be called, how they like to be addressed, whether the whole, what is their problem, just a little bit to get to know each other. So that's the job of the introductions, but that's got a very important role in terms of how you start ensures how you will continue. So the right in the beginning is first impressions about you, the mediator, about your neutrality, about, about the process, because it's hard for you to bring your conflict to a space, particularly if you know that you can get into litigation and it is, you have a good case or you will win, and you come with all those kinds of impressions. You could also come with impressions where your negotiation process has failed in the past. So somewhere this stage helps you set the stage for the next one. In this stage, and we'll come to that in terms of what introductions are, and also how much the parties can speak, how much the mediator speaks, what the mediator speaks. All of that is something that we look at in the stage of introductions. Then there is the stage of communication. Communication is a stage where you understand the problem, you build the agenda, you gather information, you identify issues. So a problem will have multiple issues. It won't be just, in many cases, it won't be just one problem, like one small thing. It will have multiple layers and issues. So you identify those, and you facilitate dialogue. The aim of this is to, when people come, as I told you yesterday, several times they are not in talking terms, or every time they talk, they are language or the way they interact keeps escalating in terms of the kind of anger or emotional issues that there are. People sometimes are just avoiding the conflict. Sometimes they are very aggressive and getting into that entire competition area. So the mediator's job is to get them to a level where they are in a position to listen to the other person and say what they want to say. Here, the key is the parties speak and parties listen to each other. In communication and the stages going ahead, we do use joint sessions and private sessions. Joint sessions are where all parties and their lawyers are together and you have a discussion. And private sessions are where parties and lawyers, only one party and their lawyer, or just the party, or just the lawyer, or just lawyers with each other are together. And you are talking to them. The other party is not part of that discussion. So that's called a private session. It's also called caucus. So that is also what is done in the stages that after introduction. Some people also use private sessions before starting the process, where they feel that the parties are very angry, or they haven't they've had history of litigation, or there's history of violence. You may want to have separate sessions right in the beginning and then start with joint sessions. So that process is flexible, and that process in terms of when to use what tool. So what I'm talking about is a type of tool. We'll deal with tools one by one, why they are used, what they do, how to do them. We'll do that. So some of the tools that are used at these stages are joint and private sessions. It's the mediator's option which tools they use at which stage. Any questions so far? The third stage is problem solving, or third step. In problem solving, now some of these terms you may not understand, and we will be picking up each of these terms and understanding what they are and how and when to use them. Transition to interests, generate options, explore Vatna, Zopa, avoid and overcome impasse, and negotiate. So when we go to this stage, we will be looking at what are positions, what are interests. We'll be looking at how to generate options for solutions. Best alternative to a negotiated agreement. What are the options available? What is the worst alternative to a negotiated agreement? What is the zone of possible agreement? All of those are things that we try and understand and explore during the problem solving stage. And impasse is something that we must expect in mediation. When you're dealing with conflict, impasse is one of the things that happens often. And it's a mediator's job to see that we overcome that impasse. We expect it and we overcome it. So what tools to use for that? Those are the things that we look at: problem solving, negotiate, and try to generate what are the options that are available for us to find a solution. And the last stage is agreement or closure, where we learn how to terminate or close a mediation, irrespective of whether it has reached a settlement or not. If it has reached a settlement, we learn how to make that settlement agreement. What are the ingredients of the settlement agreement? What should we ensure when it happens? And if there is no agreement, we need to tell the parties what next. So we look at that when we look at the last stage of closure. So basically, this is the process of mediation.
Madam, please explain what is Bhatna, Vatna, and Zuba.
I'll tell you the definitions. I mean, what they mean in terms of their this
sorry,
thing.
I had to go out somewhere. In between, I have missed that part.
Okay, so basically, Bhatna. So all of these are tools. Okay, and these tools will be explained at the problem solving stage. And what they mean is best alternative to a negotiated agreement, worst alternative to a negotiated agreement, and a zone of possible agreement. So when we reach the negotiation stage, we will look at each of these tools, how to explore them, and when and how to use them. Any other questions?
ZOPA is what? Zone of
Of
possible.
possible agreement.
Zone, Z-O-N-E.
Yes.
Oh.
So in the introduction stage, the introduction is of the mediator and the parties, the process of mediation, and the ground rules that the mediator sets. This is done through something called an opening statement. And every mediator in every mediation is expected to deliver an opening statement, which kind of makes the parties understand what it is that they should expect in the mediation. It is also for the mediator to tell the parties who he or she is and what they're bringing to the table. So that's what an opening statement is. A mediator's opening statement is meant to build a comfortable space in which dialogue can begin. So we are creating that environment for people to talk to each other. And for that, the first thing we look for is the comfort of the parties, which can be verified by checking their sitting arrangement, ventilation, lights, checking the language and comfort, material arrangements such as access to water, washrooms, coffee, tea, any other such thing that will impact their ease of discussion. We must know that some mediations now happen online. So when it is online, checking a simple thing such as whether their videos are working, ensuring that no recording is happening, that recording has been disabled on the platform, seeing that the background is not blurred for all participants, because you always have that doubt that is somebody behind and recording, is somebody else in the room. So those kind of things can be ensured to see that parties feel safe. I had one of my first online mediations during the pandemic. And one of the parties was not used to, obviously at that point of time, none of us did not know how to use the platform. So, and the other was a corporate giant, and they obviously all of them were very comfortable. So the lawyer of the party, told me that he's joining from another location and it might be challenging. So I had a private session with the party before the mediation began, just to tell him and teach him how to use Zoom, how to raise hands, how to, basically work on the platform. That itself helped me build rapport with somebody who was, very uncomfortable with the process. When he joined the next time, he was very comfortable. So every situation will demand something else in terms of building that relationship, whereas you are not really building friendship or a bond, but you want them to believe that you can be trusted, you are somebody who cares, somebody who listens, and somebody who understands. So the objective of the statement, as we've said, is to build trust and rapport, to validate the choice that they're making as, of choosing to mediate. Educate the participants about the process, the role of each person in the room, the schedule. So having discipline in terms of how the process goes, that's in the control of the mediator. And one of the ways to control that is to have consensus. If you're going to set rules, people are free. And when they are emotional, they're not going to listen to you. So one of the things is to, tell people that, can we do this like this? What do you think? Can we allow the other person to speak? And only after they speak, we speak. We keep ourselves on mute till the other person speaks, or we wait, for one party to finish and then we speak. We are respectful. We come on time. All of these things are setting the rules, but they are not imposing the rules. They are asking for consensus. And we find that when there is consensus, parties themselves agree, yes, I understand this is for my good. This is how the process will proceed. Then they do their part. And if the other one doesn't say, we are not interrupting, they are interrupting us. So then the other one also stops doing it. So it's a very nice way of doing it rather than imposing it on them. But of course, you find your own style. You see what works for you. If you can't command the process without really setting rules, it's up to you. So you should figure out what works for you. What are the contents? Welcome and introductions. It's good to check names and pronunciations, disclaim any bias, explain the process of mediation, explain guidelines, and questions. So if there are questions about the process, take it up. Yes, Rushali?
In your slide, you have marked the fees as red. Any specific intent behind it?
So basically, this question comes up very often. So that's why we marked it. That, what do we discuss the fees during the opening statement? So fees, it's best to disclose that, in all probability, by the time it's the opening statements, your fees have been agreed to, signed off, and even paid to a certain extent. So at that point of time, you tell them that, these are the fees. But most important is to tell them that the fees are paid by both parties, if they are. Or if they are not, if one party is paying them, which is something that we don't recommend, then you basically say this party is paying, and but I'm neutral, but the parties have agreed that this party will agree to will pay the fees in total. So that kind of making it clear in terms of what the fees are, and the fact that the fees do not impact your neutrality. Who pays the fees does not matter or influence the neutrality. It's important because several times there is a request that one party pays the fees, and that's that's many times viewed as a little bit, you take a little longer in the caucus with the other part, with the party who's paid the fees, and the party who's appointed you, and the other party gets jittery. What was he telling you? Why were you taking so much time? What did you tell them to do? So maintaining neutrality also requires you to have that transparency.
And the time that you're talking of is the time as in the duration for which it is allocated for the mediation in terms of hours or number of days. How is it?
So basically, many agreements have a timeline. Mediation should be over within 15 days. Mediation should be attempted for a period of so many days. Then that time needs to be told, or there is a deadline given by courts that you should revert. The mediation period is 90 days. So putting that out there is good. Many times parties themselves want it, that we don't want to waste months in mediation. We give it 15 days or 1 month, and if we resolve, fine, otherwise we are going to court. We don't have that much time to keep letting the other party take their time. So if you want it to be, it's a time bound process. And if you want to extend that, then permission of both parties is required. Keeping track of that is important. It's also about the time of the session and time of how much time you spend with each party in a caucus session. So all that transparency is required to give the assurance of impartiality and neutrality. Yes, Mr. Praveen.
See, at times fees are dependent on the number of meetings or the time spent. Then
Yes.
how upfront or we decide the terms and say, I'll be charging something X amount per hour or something.
Yes.
See, all professional
Session.
lawyers charge that way.
Of course.
So if you decide say X amount and then if the matter goes on for say double or triple time, then we lose. Or if it is so simple that we decide and then matter may get over in a week's time also.
Absolutely. So that is all that is to be decided depending on what terms you set. Those are the mediator's terms. If the parties agree to that, then that is told to them. So it could either be on hourly basis, it could be on a session basis, it could be on a quantum basis. But only thing, it cannot be dependent on the settlement.
Because settlement is not fixed, no. Settlement, because they may
Not
drop
only
out,
it
they
is
may
not
walk out. They may walk out any moment.
Not only that it is not fixed, the fact that you are really not interested in, you have no interest in whether they settle or don't settle, or you should not have an interest to such an extent that you force them. So your compensation has to be the amount of effort you put in and not the outcome, or not how much one party gets or what they settle at or the quantum. So that's very important. It may be on the quantum of the dispute. That happens many times, in the sense, just like how we value suits, the same way we can value a mediation and have fees as per those brackets, but it cannot be dependent on the settlement amount. Or if the matter settles, you will be paid so much, and if the matter doesn't settle, you will be paid so much. That creates a kind of a pressure on the mediator, one part, and it also creates it creates a bias in the parties' minds. Of course, there are some places where this exists, where you say if the matter is settled, you will be paid so much. If it doesn't settle, you will be paid so much. But if you want to have like good practices, one of the good practices is not to relate your fees should not be related to the settlement. It should be independent of that.
And secondly, they should make progress payment. Otherwise, the one day may walk out just, and then nobody is interested in paying your fees.
Yes. So again, that is, if it is a private mediation, it's best to get the fees in advance. If you on a session to session basis. So that's everyone has to, just like lawyers, just like chartered accountants, you have your own way of recovery or ensuring that you get paid. You have similar, kind of, I mean, similar kind of direction, arrangement where they pay you. I mean, you ensure that you get paid. Of course, we are still, mediation is still at that area where most of us are not working for the money. We are working because we like this, we like this job, and we do it for the satisfaction. Yes, the profession is growing. But at the same time, money is not the primary reason why people are into mediation today. Dr. Balsara?
So this timeline, should you fix it right from the beginning with every case, or it just goes on and on
it
and on like a
depends,
court case?
It's better to fix it, but it's not mandatory because some cases require the time. So you don't
what is the
rush.
maximum that you have
There's no such
encountered?
thing. There are no guidelines in terms of the time. But if it's court annexed, many times they give you 90 days to attempt mediation. There are agreements where people agree 15 days, 30 days. So depending on how many sessions you can fit in those. So that kind of thing. But it's completely to the left to the discretion of the parties. Not the mediator, by the way. Mediator can fix the session timing for himself and certain rules within that, but not really how long the parties will mediate for. That's something the parties agree. If you feel you want to propose that, you may explore it with the parties and fix something like that.
So do you do
But
it
it's
on a
not
daily basis? Do you do it on a daily basis, like once you start the
This
mediation?
time that we are talking about is both. One is how long your session will last. I have had sessions which have lasted the entire day with breaks in between. That is because that builds, it's easier to go through this, the communication. You also have focus. It's done in a place where everybody comes and sits in that office, puts off their phone and just focuses on the mediation. So that's very helpful, where there is a lot of emotion involved and all of that. That kind of allows you to use various elements such as silence, leaving them in a room, coffee breaks. Your process continues even though you are not intervening. Or you have short 1.5 sessions if it's online. If it is in person, we have 3-hour sessions. So you design it depending on the case and depending on the mediator's convenience and the party's convenience. So that's how it's done. There are no, because it's a flexible process, there are no guidelines as per that into strict guidelines. So I think we've understood this. The opening statement enables the mediator to introduce yourself, to set the tone, explain the process and your role, and provide practical information. Setting the ground rules. A mediator should set some ground rules, such as each party shall speak in terms. Should they object to or further clarify what is being said by another person, they shall not interject, but shall make a note of it and speak when it is their turn or at the end. So speaking in turns, and they should give only a brief understanding of the dispute at hand from a perspective, from their perspective in 5 or 10 minutes, as there will be ample opportunity for more elaboration and discussion later on. Okay, so such small things, because you will notice then when you actually deal with the case and people are angry or in a conflict, they don't want to let the other person talk, or they don't want to listen. They want to express themselves because they feel they are wrong. Each one feels they are wrong. So they really have to express themselves. So they find it very difficult and they get triggered by sentences that are used by the other side. So allowing that is very important to diffuse not allowing that and allowing each party to speak is important to diffuse the tension. What are the ingredients of an opening statement? Introducing yourself and seeking introduction of the parties, their lawyers, what language. So one of the things that really helps building trust is to find out what language people are comfortable in. Not everyone is comfortable in English. Some speak Hindi, some speak Marathi. In fact, even if you know English and you have a group of people who speak either Marathi, Hindi, Gujarati, you'll see that for them to communicate, it's easier in that language. And if you understand a little bit of the language, don't stop them from speaking in that language. Because eventually the communication is between them and not with you. Okay, so I recently had a case where everybody spoke English, but they came to the session and they started talking to each other in Gujarati. And first, they were not willing to speak to each other. It was one of those cases like Mr. Praveen had mentioned, where one of the parties, the one who was supposed to get money from the other, the creditor, refused to go to the other person's office to pick it up and to kind of discuss it. When they came to the table, first they were very angry. They shouted at each other and all that. And eventually, they brought in that term, bhai bhai. And then they started talking. I had to just sit and listen. Because then that conversation was happening at a level where they were finding their own solution. They were not fighting anymore. You intervene if you feel that the communication is not going in the right direction. But where you see that they are talking to each other, trying to understand each other's perspective, don't intervene. If they're talking in some other language, let them. So when you introduce itself, you ask them what language they're comfortable in. If they say they understand English, fair enough. But you say, are you comfortable in English? And they say, no, I'm more comfortable in Marathi. And if you can speak Marathi, speak Marathi. Let's conduct the whole thing in Marathi. It's about the comfort of the parties. Welcome participants, including the lawyers. Lawyers are a very important part of mediation. They're not mandatory. You don't have to have a lawyer in your mediation. But if they are there, welcome them and utilize their services. They can be very helpful. Disclosure, neutrality, conflict of interest. So disclose if, for example, one of the parties, their brother or sister was your classmate in college. You have no relationship with them. You have no relationship with the dispute, but you know who they are and they know who you are. A fact like this can make the other person feel that you have a bias because, you were friends, because suddenly being classmates becomes friends. You were friends with their sibling. So what you need to do in a case like this, where you are aware of this and you've been appointed because you had no conflict of interest with this, both the individuals and the matter, you disclose it. So it's called a disclosure, where you say, I went to college with his brother or sister and I have not been in touch with them, or we are not friends, or we have no relationship with each other. Do you have an objection if I continue to be the mediator, or or are you uncomfortable with this fact? If the parties say that they are comfortable, proceed. If they say they are uncomfortable, recuse yourself. Okay. Neutrality. So expressly state that you have no conflict of interest in, you don't know the parties and you have no interest in the in the matter of the dispute or the outcome. If there is anything that is mandated by law, disclose it. For example, any fact that discloses sexual harassment of a child. We all have duty to disclose that. If, for example, there is, danger of hurt or injury or suicide, and if you feel that you need to, protect yourself if such a thing is disclosed by the parties, you may want to tell them that. Of course, the others are not mandated by law for disclosure, but the first one is a mandatory disclosure under the law. So you need to let them know that certain things are mandated by law, and if that happens, I will have to disclose. Okay. Yes, Dr. Rai.
I am not clear with this mandate by law thing. Can you
Yeah, so
explain
basically there is a law called POCSO, which makes it mandatory for all citizens of India to complain or let the police know if you are aware of a fact which that a child is either being sexually harassed, or there is a danger that the child can get sexually harassed or abused or exploited. So that fact needs to be disclosed. So while you are completely governed by confidentiality in the proceeding, there are some things that makes you, you may want to disclose, or you may want to raise an alarm about. And this is one such thing, because this is required by law. So if you have any such requirements as an individual, either by law or not, you should disclose that, so that parties don't, parties know what they're getting into. Because the right to confidentiality is a very, very important right for all parties in a proceeding.
So you mean to say there is something during the mediation you get to know
Yes.
is wrong as per law, and you will
Yes.
definitely be informed. So you have to
Yes.
truly tell them in advance.
You have to tell them in advance, because they have a right not to disclose it, or be careful about it. But if you come to know, you are under an obligation to disclose it. So that they should be aware of.
Okay, these things are documented in the before you take up the mediation.
You don't have to document it, but you have to disclose it. I mean, basically, at the time of your opening statement, make that statement so they know, okay, other than this, everything else will remain confidential. So even if there is a threat to the other party, there's no mandatory provision of the law that you have to go and complain about it or raise an alarm. But you may have your own standards of certain things. If that is there, then you may you may tell them, but those need not be told in advance or things like that. But where there is something that needs to be, there is a element that you suspect that such a thing is possible and it's mandated by law to be disclosed, it's best that you make the parties understand that there is complete transparency, that certain things I am mandated by law.
Yeah. Please repeat the law and please write down the law in the chat box now. I could not understand
POCSO. Okay. So you mean to say that one of the parties is a child molester who's come for mediation?
So that may or may, I'm not saying one of the parties. One of the parties.
I didn't understand.
So it could be that okay, for example, they may make an allegation that my father-in-law, I'm just making a random statement. My father-in-law, there's this neighbor who leaves the child in our house, and I'm uncomfortable because the father-in-law is, he is kind of a very, he makes advances towards the child, which I'm not comfortable with. Now, a fact like that, you are mandated by law to disclose to the police.
But what's that got to do with the mediation process?
Exactly. It has nothing to do with the mediation process, but it makes it mandatory for you to report it as per the law.
But the mediation is completely different.
Yes, the mediation might be completely different. It could be disclosed that, you know, there are advances that he is making towards my sister's son. And that's why I don't like him, my husband. So I'm in a divorce matter. My husband is doing something, and that's why I want a divorce to my sister's child.
Okay.
So that also could be. Now that's something that you will need to take action against, because as a citizen, you are obligated.
So you would go to the police as a mediator?
Yes, you would need to under the law. In fact, you as a doctor would need to go to the police. That's the law. If you come to know something like this, under the law, you are supposed to go to the police.
Without any proof.
Yeah, you just have to inform. You are an informer. You are not a complainant. You are a whistleblower. So your name doesn't get disclosed. They don't question you. It's not about you. It's about protecting the child. All of us have a responsibility to protect the vulnerable and children, more importantly. So it's just one of those things that you should be aware about. Don't get so serious about it. If you may or may not do it, but if you feel that there's a case where this could be involved, mention it. Okay. Yes, Roshali.
Will it true for criminal offenses also?
No, that is not mandated by the law. There are no other mandate. Even if you are a terrorist, there is no obligation on the citizen to disclose that to anybody. This is the only provision of the law that requires mandate, and that's why I brought it up. But see, it's you could be under different in different areas of work, and you could have certain different obligations. So whatever are your obligations as a mediator, and if anything is legally an expectation from you, you may disclose that. The idea is to keep transparency. Understand the ultimate idea. The idea is to keep transparency and build trust and rapport. So as much as you feel you need to in a particular case, you do that. The fact that the process is voluntary and the parties can exit it at any point in time is another fact that you need to disclose. We've already discussed the point of fees. Role of the facilitator, non-advisory, non-judgmental. You explain your role, because as I told you, a lot of people come to the mediation believing that you are somebody who has the right to decide, and that you will help them identify who is wrong and right. And that's not your job. Your job is to help them have a dialogue. So making that very clear in the beginning also makes them more comfortable to share even if they are wrong. And that's the idea of doing this. Confidentiality, benefits of mediation, a little bit about the process, how it's going to benefit, the fact that you're going to, if you come to a settlement, it'll be a settlement of your choice. I always prefer, while we say finality saves cost, time, and energy, I don't like to refer to mediation as a process that's not, that's cheap, or we're choosing it because it's inexpensive. We're choosing it because in that situation, it's a better process. It's helping you choose your own solution. It's helping you resolve something at a level one-to-one without making it worse or escalating the conflict further. And that's why you're choosing it. The time, energy, cost is an additional benefit. I don't think anybody should choose a dispute resolution process just because it costs less. It should be okay, this is the cost, but I want this because of these reasons. And I think mediation has a lot more reasons than just cost, which is what it was marketed as in the beginning. It was also marketed as something that would reduce the burden of the courts. Yes, it does. but that's not the primary, the primary quality of mediation. There are many more, and highlighting on those is a very good way to build the commitment of the parties towards continuing the process. Because let me tell you, it's not easy. It's like digging into, it's very easy for you to give your matter to a lawyer and let him fight it. It also gives you that adrenaline rush that somebody is fighting for you. You are going to be proven right. You get to say what you want to say. So it kind of, it gives you that push, or rather that happiness that, okay, I'm being heard, and my rights are going to be protected. But in a mediation, it's hard. You deal with you deal with emotions, you become vulnerable, you start reflecting on your own mistakes or faults, and that's very hard for all of us. It's easy to blame, but it's very difficult to introspect and reflect. And that part, to continue, you need to know why you're going through that process. And that's why the opening statement is such an important part of mediation, to prepare the parties to stay strong through that uncomfortable process that is bound to be there in between the process. Joint and private sessions. So I'll get to the part of what happens in joint and private sessions exactly. But parties need to know that you will be calling for private sessions. That they will have an opportunity to speak to you and explain their point of view, which they may not want to share with the other side, some facts, some information, and that can be done privately. The fact that if they reach settlement, there is finality, or whatever it is, what type of mediation it is, where it's being held, and what will happen to the settlement that they draw up, and what will happen if there's a non-settlement. So depending on when they have approached you, that's when you will know what happens if there's a settlement, if there's no settlement, and you can explain that to them. Because it's a confidential process, and in some cases, not all cases people care so much about information being written down, but in certain cases, particularly where a lot of business information, confidential information, patent related data, those kind of matters come up, people are uncomfortable if you take notes. And they want to know what you're going to do with the notes. So it's better to be upfront and say that I will be writing notes if you will be. I will be writing notes during the process. I'll be doing it on, in front of you, and I will keep it till the end of this matter, or till whenever you want to do it. And at the end of it, they will be destroyed. At no point will I use them for anything else. So that's something that the parties have a right to know. What happens to the notes you make? What happens to, when they are using their names and writing about their personal facts? What happens to all that information? Do your juniors have access to it? Do your chamber colleagues have access to it? Do your fellow colleagues have access to it? Does your spouse have access to it? All of that information is really important for them. So just making them comfortable on that front, particularly where there is information of the nature where such doubts exist, or such reservations exist. What we are doing is we are going to give you a kind of a checklist. It's not everything, because opening statement is very personal. Everyone, and it's personal to the mediator. It's personal to who your parties are and what is happening. And it's also very much dependent on the facts of the case. So your opening statement will be drawn up by you, depending on all these things. But most importantly, it's about you. And therefore, that checklist may not have everything. It just has some guidelines. it's not, it's not like you have to have every point. It's also not as if all the points are there. So whatever you feel is important, you put it there. The primary objective is whether the person who is in the room and listening to your statement, that person trusts you at the end of it, or is in a position to trust you. And if you've been able to build a rapport, if you, depending on your disposition, if you can use humor, you can use, any other of your own personality traits to build that, you should use that, because it's very personal and very much reflects who you are. Apart from the mediator, the parties also introduce themselves. What they do is, of course, they say who they are representing. They talk about the nature of the problem and state basically the crux of the problem in brief. It's not a place where they go into details. So basically you can give them time, 15 minutes, 20 minutes, talk about what happened. There will be a lot of details that will not be there because you've given them a little amount of time. It's not really a venting space. It's a brief of the problem. Many times we ask parties to give us that in writing. But remember, it's best the party speaks and not their lawyer. Or both. Let the party speaks first and the lawyer speak. Lawyer will talk about any history of dispute, any legal points, where they stand in the under the law, those kind of things. But the party will speak about how they see the problem. When you tell the lawyer to give the statement, there's a format in which lawyers will talk. We don't want that. We want it to be free flowing in terms of how the party sees it. And state the history of litigation between the parties in brief. This is what the lawyers do. Give a synopsis of dates, events, and dates and events for ready reference. This is optional. Not all mediations have lawyers in them, or sometimes one party may have a lawyer, one may not. So it all depends. But we are here to hear what the party perceives the problem to be. So focus on that. And I'll give you a difference in terms of, yes, Dr. Sirur.
So typically, does the mediator tell them to prepare this opening statement well in advance, or it's extempore?
Many times it's extempore, but okay, so let me tell you, many times we have a call with the parties, like a call to tell them that, this is the date we are meeting at and all of that. And you may give them a little, this thing that prepare your opening, prepare a small statement about what the case is, not in detail, just what you are looking for and what the problem is. That's it. And always give them a timeline, because otherwise they'll continue for an hour. They've been waiting for somebody to listen to them. So give them 20 minutes, 10 minutes, 15 minutes, whatever you are comfortable with, and depending on how much time you've reserved during the day. And I've also found that in larger disputes, like corporate disputes, where there is, business dispute, and where there are lawyers and all that involved, you can ask for a written opening statement from the parties. When you have that, you kind of prepare your own strategy in terms of how I want to explore it. So that's also helpful. It depends on case to case. Court annexed cases, there's no such chance. There's a small brief you will get from the court, and you will basically have to depend on that. And parties don't submit anything in writing and all that. They come to the mediation, you ask them, and they speak. My experience is most of the times they know exactly what to do. So it's not such a difficult thing. And of course, there's no training involved here because parties are never trained. Parties are people who just come in. So you should be aware how to get it, how to control that process and how much you allow them to speak. So I can tell you that there was this one case where there was one party who had a lawyer and the other party came without a lawyer. And the way the opening statement was of both of them was so different. The party who came with the lawyer was the applicant, and there was it was some recovery of some amount. And they said, this is the recovery amount, and we sent this notices, and this transpired. This amounts were paid on this date, and we sent notices on this date, and they have been avoiding the discussions, and this is the liability, this is the interest, this is our claim. Very simple. So then we went and listened to the other side. The other side did not have a lawyer. They hit directly on the problem. They said, we had a very good relationship up till now. There was something that went wrong during a wedding. And these people are related to me. They are my uncles. And during the wedding, they felt insulted that they were not given the respect that they deserved. The wedding happened 1.5 years ago. And at that point of time, this issue happened. And from that time, they are wanting to recover money, which they are really not interested in. And I have come here so that I can talk to them and resolve that issue if whatever it takes. Because for me, money I will return. I need little time, but money I will return. But what I'm want to do is also talk about that issue. The party's focus is very different and the lawyer's focus is very different. Party goes deep into the problem, exactly what they want. The moment then I shifted back and I asked the party to speak, I asked them, and this was the explanation one party said, and they said, maybe it happened during the wedding. I don't know, but something happened, and past 1 year things have, something has gone wrong. So I went back to the other party and I said, what exactly happened? Tell me where the problem started. It started at the wedding. It started at the wedding. I gave them all this money, and then they wanted me to pay for water bottles that were 5,000 rupees or something. And why will I take 5,000 rupees from them when I have so much money that I've given to them and they owe me so much? So the whole issue was something completely different from what was projected in that legal notice. It's a proper commercial case. And I've seen so many of these kind of cases that when the parties come in, the whole discussion is different. When the lawyers come in, it's a very structured process. They know what to say because they are going as per the book. That's why focus on the party and let the lawyers support. They're important, but they don't have the first and the last say. So joint sessions. What do we do in the joint sessions? We get, yes, Dr. Balsara?
Yeah, is it not better than to not have lawyers for mediation and let only the parties be there if they cause so much commotion?
So I find lawyers really helpful.
Okay.
I mean, if you practice, yes, sometimes we have reservations that lawyers are more interested in taking the matter to the court, and they have more commercial interest there, and we have this is all our bias. My experience is 90% of lawyers are extremely cooperative in mediation. They want the mediation to succeed as much as we wanted, the parties wanted. They're just doing a job.
Mhm.
It's about making them as comfortable and telling them how they can support you rather than judging them. I have had a couple of lawyers who were difficult, But in both cases, they were difficult because they wanted something more for their client, not because they wanted the mediation to fail. So they are very clear about their objective. So as long as you understand their interest, you can use them beautifully in the process. Just don't have a bias in your head. It will be difficult. And I'm telling you as somebody who has done n number of cases, that in my entire 10 years as a full-time mediator, I may have come across 2 or 3 cases altogether. It's really minuscule percentage where lawyers have been difficult. And even the difficult lawyers eventually have been most cooperative when they've got what they wanted for their client. And I can come down to one case where I have a regret that the lawyer attended. Only one case. But even that case we settled. Just settled on terms I thought were a little not so fair to the other party.
But has it ever happened that the two lawyers only just sit together and finish off deciding on the case without the mediator?
No, it doesn't happen. They do cooperate. They do talk to each other. Sometimes they keep fighting with each other. Then I've had sessions where I've taken a caucus with lawyers. Instead of taking caucus with parties, I've told the parties, because the parties have been speaking very beautifully to each other. It's the lawyers that are fighting with each other. So I've taken private sessions with just lawyers. So it's fine. But at the end of it, it's for you to identify that they're not being difficult. They have an interest and they're doing their job. So when you understand that, it's easier for you to kind of navigate and take their support and use them in the process rather than looking at them as an obstruction. So understand, first of all, that joint sessions are basically where all parties are there with their lawyers. So when you imagine that, then you look at what we do in those. Okay, we gather information, but this is just information that the parties want the other party to know. Every case will have layers. There'll be things that they don't want the other party to know, either because they'll think that that will give the other party an advantage, or they feel that it will work against them if the matter goes to court, or whatever. There are various reasons, and there will be information that they don't want disclosed in front of the other party. That information will not come here. Nobody will share it. So there'll be a large chunk of material that will not be disclosed in joint sessions. Understanding emotions, and not just understanding emotions in terms of how they behave with each other. Okay, remember one thing, that somebody will behave something in front of the person they have a conflict with, and behind them they will be different. When they are not there, they will behave differently. Understanding that equation is also important for the mediator. So when you notice, keep an open mind, don't judge, just observe. So these are the things that you observe. Grasping issues and interests of the parties. So as much as you can grasp in terms of what have they come here for. Take note of that. Establishing communication. Building rapport with the parties and lawyers. This is key in terms of how you give them the space to speak, how you reflect on what they say, how you summarize what they talk about. The fact that you show them that you are understanding what they're saying, you're acknowledging what they're saying, but be very careful not to agree to any one party's contention. in a joint session, particularly right in the beginning. Parties can jump directly to conclusions about your partiality and your neutrality. So maintaining that and taking equal time to basically, if you feel that somebody is saying something and you don't agree with it, if you're questioning this person, also question the other person when you don't agree with something of that the other person says. So keep that neutrality and be very, very aware, particularly in the beginning of a mediation, that they are judging you as much as you are judging them. And you are a trained mediator, so judgment is not your nature. They are parties. So they are not going to look at you through a non-bias, very, open outlook. No, they will come with their own mindset. So you have to ensure that they see you as somebody who's neutral. Joint sessions are also used to take parties towards resolution. Any thoughts?
Ma'am, do you have any capping of the number of people involved in the meeting? I mean, from each side or any only the
Yeah, so basically, first of all, so in India, we have, it's quite complicated. Relatives will join in. Then even neighbors sometimes. So you have to, you have to basically allow the decision makers and key decision makers and key people who are affected. If it's a business dispute, it's a corporate dispute, it's best to have every department represented. For example, and of course, all of them need to come with their authority letter where there is a business dispute. So if, for example, finance, legal, don't encourage people to come, like one person comes from the company and they go back for every decision. I'll check with finance and come back. I'll check with legal and come back. I'll check with the engineers and come back. That shouldn't happen. Your technical department, your legal department, your purchase department, whoever is involved in that dispute should be represented, or the person who's come has to be briefed properly. So decision makers at the table is important. There's no cap, but frankly, having 20-30 people in the mediation will be very difficult. So, I mean, I have had mediations where we've been about, say about 18 people, 18, 19 people, like a large conference room with, but they were mostly lawyers and people from the law firm. The party was a maximum of 5 people.
okay.
That's because those were corporate disputes, and when it's a personal matter, it's basically husband and wife, or wife and their lawyer. We would avoid having the entire family representing. It all depends on the nature of the conflict. But basically, the key decision makers, the next of kin of whoever is aggrieved, and 1 or 2 lawyers. But as I told you, in India, it's a little complicated because marriages are not always between people. So we've had matters where parties themselves wanted their brother, their mother, their father attend the mediation. And with express permission from both sides, we've allowed that kind of a thing at certain stages of the mediation. So there's no cap, but let's be practical. It should be possible for the mediator to talk to all of them. Okay. Yes, Rushali?
So let's say when there are multiple departments in case of a corporate dispute, which are involved in the decision making, and during the negotiation stage, they internally want to discuss about the offers or negotiation aspects, and they need a separate time. Should that be allowed?
Of course. Yes. We, in fact, a proper mediation would generally provide for a separate room for each party to have those discussions. They're called caucus rooms, where you have your private session. You don't have your private session in the main room. There's a main conference room for joint sessions, and there are caucus rooms for each party. Those discussions, we ensure that those rooms are soundproof. If it's online, of course, you make a breakout room and let them do it there. But that's one of the steps it's required. In fact, we will come to private sessions, and when we get into negotiation, there are exercises you do specifically with parties separately. That whole decision-making process happens there, and that needs them to discuss among themselves. Yes, Dr. Sirul?
I think more the number of people you have in the session, the confidentiality issue also will be there.
Yes.
We don't know how there can be leakage of
Absolutely.
information.
Absolutely.
So do you take a consent kind of thing from the members representing that party, saying
Yes.
that?
Yes, we do. We do have a agreement that needs to be signed, and there are rules which are signed by every person who's attending. Now, this all depends on how formal the procedure is. If it's a family matter, also you must remember that people find documentation a little scary. So you don't want to turn them off. You have to explain to them that this is of benefit to you. And confidentiality may not always be a big issue for everyone. It's a very big thing for people who are very private or who come from certain strata of society. But certain societies, stratas of society, everything is public. They don't care. So it depends on how important it is for your case, for the reputation of the person involved, and the nature of the dispute. And accordingly, you have documentation. But if you're going to tell me that you have to have documentation for a family case, that can be quite intimidating for some people. So be mindful of that, and then you take your call. But yes, you can have agreements like that also.
But you normally start a session with a joint session, or there can be private sessions to begin with?
80% of the time we do.
Oh.
But like in some matters where, say, particularly in family matters, large family, inheritance issue, I would rather meet each one separately first and understand. I've done that in those kind of cases. Then marriage disputes, sometimes if there is, they've been staying separately, there's a lot of fights happening, or people are not talking to each other. There's been violence in the past. It's not there now, but there's been violence in the past. All of these issues, before you get them together, you understand the impact that they have of that person being in the same room as you. Whether it will help your conflict or not, help your mediation process or not, and take a call. When we define a formal process, we define that the joint session is first and the opening statement is made first and all that. But the process flexibility is left up to the mediator. I have had many cases in which I've done private sessions before and then gone on to joint sessions when I'm comfortable that the parties will be able to at least make their opening statements in front of each other and won't be torn apart.
So whenever the matter is referred to you as a mediator, you get a synopsis of the...
Yes,
or
I
the
get a little
category.
bit of understanding either through a phone call or through the only thing I do is I make it very transparent to all the parties involved that this is what I'm doing. So if I'm having a call with party one, I will inform all the parties either by email or by WhatsApp messages or whatever that I'm starting the process, and it starts with this. It's never without the knowledge of the other person. So that transparency has to be maintained. And then you can go ahead. So don't like, there might be times when somebody will approach you, my case is there and will you be a mediator? At that point of time, you must inform them that if you need the party to be invited, I'm not going to be inviting. You may go to an institute to invite them. If both of you all have agreed to mediation, then you all come to me first. Let me start the process, and I will explain to you all the process together, and then we'll go ahead. So your strategy depends on who approaches you and how how the matters come to you. The idea is trust, transparency, and impartiality. Not just the fact that you are, the fact that they pursue you as such. Yes, Dr. Preeti.
Ma'am, do you encourage hybrid sessions also? And then part
Yes.
of them are.
Yes, absolutely.
Okay.
We do.
So how is that done? When you have a screen going?
So, okay, so by hybrid now, again, there are many forms. One form is where one party is in person and mediator, and another party is online because of the travel or whatever. So we do that. That has been done. One format is where some sessions are online and some sessions are in person. So that also has been done. So it all depends on what works, and we do that. Or the parties are in person and the lawyers join online. That also has been done. So we tend to use the process in such a way that it's helpful, it's good for everybody. Instead of making it difficult, no, this only is the format, and if we had an in-person session last time, we have to have an in-person session next time. It's not like that. And also I sometimes strategize that some difficult conversations, it's better to be in person. You avoid it when it's on the screen and all of that. So we do some sessions online, and then we do an in-person session, or where, like I told you, where it's a family matter and a lot of emotion and all of that, we have the first session in person, or the first few sessions in person, and then continue the matter online. So by then that rapport and the trust and the whole, the stage is set, then it's easier. So what you find comfortable, the process is flexible in that sense. You use the tools that are available. So that's about joint sessions. Yes, Dr. Deepa?
See, actually, the thing is that creating this rapport online sometimes might be difficult when you don't know the people around. And how comfortable do people get with these online sessions? Are they really comfortable, and do they really open up?
Most are. Some are uncomfortable with technology, not really the sessions. But and another challenge that many people have is internet connectivity. So if it is not very good internet, then it's annoying. And then people get irritated because they can't hear, they can't understand. That's difficult. But if you don't have those technical challenges, we are having a lot of matters online right now, and it's going quite well.
Okay, thank you.
So what are the mediator's challenges in a joint session? Maintaining neutrality, managing emotional outbursts and interruptions of the parties. So we have to be aware of these challenges, and we must know that one of the things is to expect them. So when you expect them, you're not taken up by surprise. You're just not taken up, like it doesn't surprise you all of a sudden, and it doesn't you don't take time to react. So when you know that these are the challenges that come up, you're better prepared to handle them. Controlling the language of the parties to maintain conducive environment. So these are ground rules, reminding them of the ground rules. And if required, even breaking off into a private session if you can't control it. That's one of the things that we do. Noting the demeanor of the parties, shifting the parties from past to the future, moving the parties towards a resolution. Now remember, in mediation, our focus is always in the future. We understand the past, but we don't judge the past. We are not really looking at finding fault and pinning the blame on anybody. That's not our job. Our job is to say, okay, this happened. We understand. What next? But that what next should not come at the cost of the other person feeling not heard or not understood. You have to understand the issue, but you have to move towards the future. Private sessions. A private session is a separate meeting with each party, with their lawyer, without their lawyer, just with the lawyers, or just with one lawyer, or even with a third party who's not really the decision maker, but you may need that party's, I'm not really saying inputs, but may need that party to be, to bring that party on board. For example, relatives, other interested parties, or finance, chartered accountants or accountants, people who have certain information, because the party may not be able to translate it for you. They may say, meet so-and-so, and they will explain it to you. So you may have a private session with them, with the party or without the party. I've had sessions with in-laws of, couples. They have no decision-making power, but they are very, very important in the scheme of things, particularly in the Indian context. So you do that, but knowing fully well that they don't have decision-making power. But they will influence the outcome. So what do we do in a private session? We deal with the emotions. In the joint session, we understand the emotion. We give them a space to be expressed. But in the private session, we explore the emotion, and we may even allow that emotion to be dealt with. If someone is sad, that sadness may come out as anger, that resentment may come out as anger in the joint session. But in the private session, they may choose to cry. They may choose to show their vulnerability, which they may not show in the joint session. That's a space for them to do that, so that they don't appear weak in front of the other person. But and I'm telling you, in a private session, a person completely changes, because they've been holding up this really, brave front in front of the other side. But inside, they have their own fears. They're vulnerable. Giving them that space to be vulnerable, to be able to process what's going on, is what happens in the private session. Directing the parties from their positions to the interests. Now, this is going to be dealt with in detail. What is position, what is interest, and how to go from positions to interests. Okay. Developing confidence in parties. Remember that it's difficult to take decisions. And it is the mediator's job to explore why there is a lack of confidence, why parties are not willing to take a decision, or what is it what are the fears that are stopping them from taking a particular path. All of that is done in a private session. You don't give them gyan. Remember that also. We are not here to tell them that we are in any way better than them or we know more. We are there to explore, to help them understand what's going on with them. Educating a party to have effective negotiations with the other side through effective communication. Aiding decision making, generating options and proposals, and reality testing. Yes, Rajan, you are right. It's a major advantage of a in-person session that you can read body language. You have eye contact. In fact, I describe this very often, but just taking a short coffee break makes a huge difference in terms of how people interact during the session and during a break, and that can actually help break the ice. So those are advantages of the joint session. But another thing that I've noticed is you can have more frequent sessions if you have private session, if you have online sessions, because people don't have to travel, especially in a place like Mumbai. You're traveling from one place to another. You have to take a break from your workplace if it's not a workplace related dispute. That's a problem. So everything has its advantages and disadvantages. I have two parties from Bombay, and they keep saying let's have them online, because to travel from one place to another, first of all, I have to travel and they have to travel. It's really complicated. So what advantages you want, you choose your medium. Over here, reality testing, aiding decision making, generating options, effective communication, positions and interests, dealing with emotions, all of them are being handled in separate sessions. We will have exercises and we will deal with them in separate sessions in terms of how to. So I'm not getting into the how to now. It's for you to know the entire process and then keep knowing a little more about each of the tools. So what are the mediator's challenges in a private session? Managing confidentiality. Sometimes we are so eager to pass on some information because we see that will have an impact on the ultimate solution. So we are eager. So we may forget the fact that everything that's spoken of in the private session is confidential. And every point we need to ask express permission of the party to be able to share it with the other party or to discuss it in the joint session. So be careful about that. Encouraging the party to put his or her point of view to the other side. So they may tell you something in private, but they may not say it in front of the other side. It's your job to kind of encourage them, to let them, to say it to the other party, because, sometimes we say mediation provides that venting space. But venting is possible only when the space is provided by the other party, not by the mediator. We don't want to be heard by random people. We keep talking to other people, but there is that one person we have issues with who we want to be heard by. So till that happens, you will not feel heard. And therefore, passing off that message on channeling that discussion in such a way that that venting actually takes place and the parties feel heard is your job. So recognizing that and encouraging the party to do that is something that you do in the private session. Shifting the parties to the next stage. So sometimes you get stuck. I have been stuck in this emotional stuff for literally several sessions, months together at times, with matter not moving forward. So then you have to have some strategy by at which you stop it also, because you're not a counselor. And you tell them that you need to go to a counselor, or you need to seek help from that side. They're not interested. They want to talk to you because they feel that they can influence you to influence the other party. But that's not even your job. So recognizing that and shifting them to the next stage in the private session without really exposing them to the other party. Remember that your whole job is to protect both of them. Moving the parties towards resolution, maintaining empathy. Sometimes it's hard to be empathetic in front of, in a joint session, because you may appear to be biased to the other person. And you can do that comfortably in a private session. So keeping that balance, understanding why you're doing that. So one of the things is to be completely present, being aware of not just the parties, but also what's going on for you. Any questions so far? So let's
So
take a
do-
10-minute break. Okay, yeah, tell me.
Yeah, sorry, ma'am. I mean, does it happen that they ask you what's your opinion on the whole thing during when the sessions are
Many
going on?
times, and it's really hard to dodge that question.
Exactly.
It is hard, but you have to.
Okay.
They keep asking, what's your opinion? What should we do here?
Right,
In
right.
fact, I've had people tell me, आप figure दे दो, हम agree कर देंगे. आप figure दे दो. I'm not supposed to give them the figure.
Correct, correct.
They keep saying, both of them say, मैडम आप figure दे दो, हम लोग agree कर दें. आप figure दे दो, हम लोग agree कर देंगे. And you have to keep pushing it that it's not me who's giving you the figure. You have to give the figure. Then that becomes a challenge, but yeah, it's very common. It's about how you dodge it and you.
Diplomatic, I guess.
Yes, Rajan?
Uh, in the course of your discussion, you had mentioned that there is a public duty, that as a good citizen, we are expected to report.
So, Rajan, can I hold that question 1 minute? I'm going to now take a break for 10 minutes because we have to continue after that. So those of you who want to take a break, please take a break. And Rajan's question we'll take at 9:30. Is that okay? So that we've completed, and then we'll discuss it at 9:30, because this is that same matter that came up earlier. So we'll discuss it at 9:30. Is that okay, Rajan?
No issue.
Yeah, thank you so much. So what we just looked at, we had an overview of was the stage of introductions. We looked at opening statements. The second step of mediation is communication. In communication, so remember, I keep saying this, that parties will come with, they'll come where their relationship is at various levels. Sometimes they'll be screaming at each other. Sometimes they'll be talking to each other, but not really talking to each other. There has been a breakdown in communication. Sometimes they'll be having conversations, but they'll keep going into circles of that communication, not really advancing in where they're trying to go. So whatever stage they are at, you have to understand that. You have to also understand what is the problem between them. And you have to bring them to a stage where they're actually able to speak, to listen, to discuss, to negotiate, and move forward. Okay? So that is the objective of the stage of communication. In communication, when we are trying to establish that, we are not looking for solutions. We are only looking to understand the problem. If you start looking for solutions at this stage, you may reach an impasse, because it's very important that the parties come to that step where they are able to communicate to each other before they actually start finding the solution. Okay, and the way the process is designed is so that you don't reach a dead wall, because parties keep reaching a dead wall. That's why they've come to a third party. So you have to do something different. And obviously they've been looking for solutions. They have explored solutions. People in their family have explored solutions. Wise people have explored solutions. What they've not done is taken them through a process. That is what you do. And therefore at this stage, you only try and find out what's going on. So, narration of the problem, private sessions to understand each disputant's perspective, joint sessions to communicate and vent out emotions, private sessions to find out positions and interests, joint sessions for setting out agenda or issues to resolve, private or joint sessions for empowerment and recognition, joint or private sessions for bargaining and negotiations. And why have I said it in, like I could have just said private sessions for this and joint sessions for this, and we've already finished all that. The reason I've said this like this is because in this stage and the stages going forward, you may use as many joint sessions and as many private sessions as you feel the need to. There's no restriction that only one private session, only in the beginning, only in the end. There's no such thing. As many times as you want to use it, use it. In fact, we have a word that we use called shuttle diplomacy, where the mediator moves between private sessions to be able to resolve a particular issue. Okay, so in communication, this is what happens. The primary purpose of this stage is to re-establish communication between the parties. Yes, Dr. Deepa.
See, here you said that you have this communication where you shuttle between the two parties, right? Then are you acting as a messenger there?
No,
And do
so
you have
we'll
the
explain
authority to do
shuttle
it?
diplomacy at the time of problem solving. At no point are you acting as a messenger. At no point you're saying, oh, he's saying so much, so he's saying so much. That is not mediation. Then you're a messenger.
That is the difference I wanted to know. What are you exactly doing? What do you exactly mean by
I'll tell you what it means when we come to that, because for that you have to understand the whole whole process in terms of all the tools. So if I tell you just one thing, then we'll be jumping the gun.
Okay, thanks.
Once the parties have started communicating with each other and they see that one of the, I like to use this word shift. You will observe during a communication between the parties that suddenly there will be a switch. Like I told you, this word bhai came up when the Gujaratis were talking to each other. That was a shift where suddenly there was this thing कि हम दोनों साथ हैं और हमको ये solve करना है, दोनों को कोर्ट नहीं जाना है. We both don't want to go to court. Let's find a solution. इधर बैठ के सुलझाते हैं. What can we do? That's a shift. At some point during the communication, you will come to that shift. You will see it. Sometimes it's body language. Sometimes it's eye contact. Sometimes it's a word like this. Sometimes it's a proposal. अच्छा ऐसा करते हैं. And from I, it will become we. Let's do this. That shift is what is a successful mediation, not the solution. That is the shift that we are aiming towards as mediators. The solution is a cherry on the cake. But that is the shift that you're looking for. When you see that shift, there are things that we do to try and find a solution, which are option generation, brainstorming to find what options we have, Vatna, most likely alternative to a negotiated agreement, evaluation of all options. We have something that we do called reality testing. All of this we will look at in the problem solving stage. Okay, in detail with some examples, with a role play, we'll look at all this. And the last stage is agreement, which is basically if we have reached a settlement, we draft an agreement. The mediator doesn't draft the agreement. The mediator supports the parties to draft an agreement. They generally come with their lawyers, or you can invite lawyers for them, but they frame it. You don't frame it, they frame it. You support them. You may ask them questions. Okay, there's an ambiguity here. So that also takes away, you all might have a question that as non-lawyers can we draft? So you are not drafting, you are helping the parties draft. You ask the right questions. So all the, there's complete clarity in terms of what you are agreeing, and hopefully have lawyers on board who will draft it for you. Closure of mediation if no settlement is arrived at. As I mentioned before, it's important to close the mediation with hope. Mediations can be attempted at several times. Sometimes mediations are not successful only because parties are not ready for settlement at that point of time. Sometime later, they might be. So just letting them know that this is an option that's open. You can come back to it anytime. Also highlighting the points that were successful in terms of sometimes there are several issues and you may have settled one or two issues and the rest may have remained open. Highlighting that. So positive parts that have happened in the mediation. Also looking at what are the options going forward, whether the matter goes back to court, whether they have other options. There's an arbitration clause in the agreement. Just discussing that a little bit and putting it out there to them, and ending on a positive note is what we do when we terminate the agreement, the process. So that is your mediation process. Yes, Rajan?
Just before we had a short recess, I was on the point related to public duty versus confidentiality.
So no, Rajan, 1 minute. We'll take it at 9:30. I still have a whole session to complete. That's
Okay. Okay.
I'm timing everything. So only if we have questions on the process, we'll take it. So
Okay.
do we have questions on the process? We'll address that 9:30.
During this joint session, if those two people talk in a language which you don't understand, you still allow them to keep doing that.
So I've never had this challenge that I don't understand the language, because I follow Gujarati and I follow Marathi, I follow Hindi, and I follow Konkani. So, and
Currently, there are Malayali fellows.
yes, and I've never had that challenge. But I think if it comes to the point that I have, I have this confidence that it's moving forward and it's positive, I will give them some time.
Okay.
I will
But
not
if you
stop
still,
it just because your local mother tongue and your language that you're most comfortable in brings a certain amount of comfort between the parties. Asking them to speak in a language which is foreign to them, just because you understand it, may disrupt that communication. The idea is that they communicate with each other. Give them space and ask them to tell you what is happening. But because language and words are not the only way of reading what's going on, you also can understand through body language, through the tone, as to whether it's positive, it's directed towards a particular direction or not.
so there might be an argument which you might not understand. So
Generally, from
having,
the tone, you can understand, and also at what stage. So that's a call completely. You take an intuitive call. If you feel
so
that
you can call an interpreter.
I wouldn't call it an interpreter, because generally, if I am a mediator, they would know the language that I'm speaking. So they've committed to it because they are both comfortable in either in Hindi or English or Marathi, whatever. And they will be talking, they will be in a position to speak that language. And the reason I mentioned that language is that I have seen many times the shift in language brings the comfort. So if you can speak in that language, speak. And if you feel that they are speaking in that language and you can't speak, but you can get an idea of what's going on, let them do it. Where you feel that the conflict is going ahead and they're fighting with each other in their language, please stop it and intervene. Your idea is to stop them from the conflict escalating. If it's going smoothly and they're really talking, smiling, looking at, making eye contact, and there's no body language that is aggressive, let it go on. Give them a little space, and then eventually ask them to translate to you what they spoke about. But this, I'm not talking out of experience. I'm talking simply about what I would do if I would be faced with such a situation. But because I haven't come across any situation where parties have continued talking and I have no clue of what they're talking to each other.
Okay, thanks.
Okay, do you prepare a written report at the end? So if you are if your mediation has failed, you don't prepare anything in writing. You only, if it's a court annexed mediation, you just say the mediation has failed. If it's not a court annexed mediation, even that is not required. There is no need to create records where there is no settlement reached. Records are created only if a settlement is reached. And that's not records, that's a settlement agreement which both parties sign. If it is a court annexed mediation, mediator submits a report along with the terms of settlement, which are drawn up by the parties. Okay.
May I ask
But
something?
there is no question of a failure report or saying why it failed. None of that. Yes, Dr. Preeti.
Ma'am, do you usually take up this one mediation issue at a time?
No, there's a little disturbance in your
Yes,
voice.
going on in the background. I said, do you usually take up only one mediation issue at a time, or do you land up taking up multiple mediations or different parties, different mediation
No,
meetings
we have
going on?
multiple going on at any given point in time.
As in personally, individually as a mediator, so how do you keep track of what's happening per session? Do you have your own notes that you make, or I mean,
So
what's
if it
happening
is-
with one
if
session to
it
the
is-
other?
If it is a personal mediation, I generally keep a book per mediation.
Okay.
And then I keep notes in terms of what is going on. I actually have a thing which you can tear off the pages. You have that book
Yeah,
which
perforated sheet.
yes, you have those sheets that you can file and take off. So I have that, and I have divided them in personal mediations, whereas institutional mediations, you have they keep the record. They have minutes that are recorded.
Okay.
They don't keep minute details of what happens in the mediation, but in terms of where we are. And those details, if I need to remember certain figures, I may need to remember, because it's that also gives the parties a confidence that you have heard them.
Right.
The last time that they asked for 1 crore of rupees, and this time you say, how much do you want again? Or,
Right.
or they mention the birth date of their child, and you ask them again and again what's the birth date or how old their child is. It does not look very good. That's not called rapport building. For rapport building, they need to feel that you know them and you've heard
Yeah,
them.
you're totally involved in it. Right?
Yes. So that you can record.
Okay.
Those kind of things where you can bring in that personal touch, but see that you keep it separately, and at the end of it, you should be able to destroy it. So that's why I'm talking about sheets that can just be removed
Right.
and destroyed.
So you have, when you start off a session, you have a few points that you take up every session, or you try to.
So that is a specific thing that we will deal with.
Okay.
There's a format to that. We'll deal with it.
Okay.
Okay, it's called
Thank you.
agenda, and
Okay.
we deal with it point by point. And sometimes we take up one. If it's not resolved, we leave it, we park it, we take up another one. We see which is easy, we see which is difficult, we see which is triggering, and we take it one by one. So that's like a strategy. So that's a mediation strategy that the mediator has. We'll discuss it.
Okay. Thank you.
Let's have a small understanding. Again, we've discussed this, so I'm going to go quickly. We are not going very much again in detail, but if anybody has a question, stop me and we'll discuss it. Okay. Principles of mediation: voluntary recourse. Parties choose one mediation voluntarily and exit voluntarily. Confidentiality, impartiality, neutrality, equality. Always remember, mediation is a form of intervention involving a process in which a third-party mediator assists parties to a dispute to negotiate over the issues that divide them. Mediator has no stake in the dispute and is not identified with any of the competing interests involved. So no conflict of interest. Mediator has no power to impose settlement on the parties, who retain the authority for making their own decisions. Now, this is something that's hard to kind of understand, that as a mediator, you don't have a role to play in the final outcome. It's completely at the discretion or the decision of the parties, but that is how it is. That's the process that we follow. And mediator is therefore responsible for the conduct of the process, control the process, while the parties control the outcome. The mandate of the mediator is confidentiality, impartiality, speed, and without excess costs. So basically, many times you will find there's a lot of wasting of time that a party will do, almost using mediation to buy time against the outcome. Recognizing that as a mediator, this is unnecessary waste of time, calling it out in a private session and going forward is your job. So that's how you're controlling the process. Supposing it's a recovery case, they'll come to the table and keep asking for time or ask for random documents or random matters will be picked up and negotiated over a time. And you can see that it's not moving forward. It's just a time buying technique. That's the time as a person who's controlling the process for you to recognize and say, okay, this is not a useful step. I need to, call it out in a joint session, in a private session, discuss it with the party and say it's in the interest of everybody that we move forward. And if it's not moving forward, understand that the process is being misused by the party. And you may want to, discuss it with the other party and close it after discussing it with the party who's doing this. Because if that is happening, there's a very high chance that nothing will happen. It will just continue. Everybody will get frustrated and the matter will end. So that is where the question of speed arises. The role of the mediator is to be neutral, to be non-judgmental, to control the process, and to facilitate communication. The solution is the outcome. The should nots or do nots make any decision for the parties. So it's not your job to make a decision. It's the party's job to make a decision. Disclose to any person or in the court any information or document which has come to him during the course of mediation. So I am given the salary slip of one of the parties in the mediation. It's come to me in a private session. I hold it. Matter ends. I am called by a lawyer, a random lawyer who calls me and says, you were the mediator in that case. Do you know what is the salary of this person? Please tell me. You have a duty not to disclose. You also have a duty that you cannot be called to court to disclose it. You are exempted from that, and you have to state that this was disclosed to me confidentially in a mediation, and I'm not in a position to disclose that. Okay, that's why you cannot give evidence as a mediator. And also, we have a duty not to take up mediations if we do not have the necessary competence to handle it. Perhaps if you do not have the confidence that you have the competence, co-mediating for some time, observing mediations for some time, may be steps that you would like to take so that you take responsibility and you are fair to the people who will trust you with a very critical part of their life. So if you feel that you are not competent, either because you hold a bias or because you don't feel in control of the process, or you feel that you do not have the required knowledge to be able to support the parties with the right kind of questions, whatever may be the kind of incompetency you may feel at a particular point in time, be aware of it, accept it, and then decide whether you want to go ahead with it or not.
Madam, for first few cases, that will be always be the position.
Yes, it will be, but
if I don't,
cost. Yeah, it should not be at the cost of the parties, in any way being harmed because of that choice. And I think there is another angle to it, that if I don't do it, where will I get the confidence from?
Yeah, unless I
Yes.
fall in the water, I will learn the swimming.
Yes,
So,
that is there.
so where
But
somewhere the one day I will have to jump.
yes, that's a call you take in such a manner that you know that these are the cases I'm comfortable with and these I'm not. I'll give you an example. When I say that different people are sensitive about different things, so you hold a bias about certain things. For example, there are people who may have a lot of what do you say, they're kind of activists in certain fields, for example feminism, women's rights, or they may be very sensitive about financial matters, financial frauds and things like that. If you are very sensitive about certain matters and you know that you cannot approach it in an impartial manner, it's best that you take up other matters first and then take up those. By then, you have trained yourself in terms of how you approach a situation. So also observing certain cases as a observer, or co-mediating some cases where you have another person who holds a lot more experience than you do in some matters, may be an approach that you would take. But where you have already got industry experience, and all you needed to learn was the process or something, and you feel that this is something I understand these concepts, I've practiced these concepts, and you have a lot of you know that all you need is to practice it to be able to do it. It's a personal call, but the only reason we are saying it is that understand that it's a personal call and do it when you're ready, because this involves the rights and the future of other people.
And if I want to do it as the observer, how I will get an opportunity? Na? Suppose Mr. XYZ is a mediator. Can I request to our institute, say that I will be interested in the, say,
Yes, we do have observations that are done in all institutes, as long as the parties agree. Even in court mediations, you can observe with the permission of the mediator, with the permission of the parties. Almost all mediation institutes allow observers with the permission of the parties. So it's common to have to be an observer. It's not uncommon. And it's also completely okay to go ahead immediately with whenever you feel like with your own cases. This is something that we should be aware of. Do I have enough knowledge to go ahead or not, is a call that you take. Each person takes it for themselves. It's not a law or a rule or anything. It's an introspective decision.
Okay, madam. Thanks. So what is the scope here? Suppose if there are only medical type of litigations, or I don't know what are the types of scope.
There are
financial, so I may be interested only in the financial matters, because that is bread and, or that is I'm comfortable. Actually, I have done some mediation without doing the mediation course at all. So I only just come. It has helped me to understand better or polish the knowledge which I am having.
Yes.
So what will be the scope in that case? I can't. And there are financial matters or only medical?
Of course, there are financial matters. In fact, there are large financial matters. SEBI has its own group. I mean, it's empaneling mediators right now. You just need to have additional courses, and if you already got experience from the stock market perspective, and if you have knowledge of that industry, SEBI has its own panel of mediators. You can join that. almost all institutes, I mean, many of the reputed institutes are empaneled with SEBI. You have mediations that go on in commercial courts, and commercial courts almost, I mean, the matters are of commercial nature, and mediation in Mumbai is still mandatory under that, because the Mediation Act is, not being implemented as yet. So there are a lot of cases in which are only strictly financial in that sense. And when you're looking at financial, almost, most cases go into finances. Maybe you will leave out cases which are pertaining to family laws or pertaining to very technical disputes, under RERA or under the medical disputes, because you feel you may not have the kind of expertise in that, in understanding them. I'm just quoting you itself.
Yes.
But almost every case will have financial angles, and understanding that is important. To be looking strictly into funding and transactional disputes, those also are available. So basically, the scope is huge. And mediation is being attempted in all kinds of disputes. Now, where to find them is in your own profession. You will have to find out which are the law firms that kind of deal with such matters. Can you have a tie-up? Can you speak to them? Which are the institutes whose clauses they have? Singapore Mediation Center, or the Bombay or CMC or Pre-Solve, or what other centers do these firms put in their clauses in the agreement, whether they put arbitration clauses or mediation clauses. It's still an industry that's evolving, and every industry expert will be in a better position to get an idea where their kind of disputes are. So I don't think the scope is less, whether it's for observing or whether it's for taking up matters. It's more about finding out where the action is. It is also the mediator's job to ensure that both parties feel heard and satisfied, that everything they wanted to say has been said. That's a very important aspect of mediation. It's important that the mediator, and we've discussed this before, that any prior association with any party is disclosed. If there's any interest in the dispute, that is disclosed. And if there's interest in the disputes and parties, frankly, there's conflict of interest, and you should not be mediating that case. But where you are still asked to mediate, disclosing it to both parties openly, putting it out there is important. That's it from us. Before we go to Ranjan's point, I'm also going to share with you the checklist. This is a little exercise that if you can work on, make a statement for yourself, an opening statement, introduce yourself. I am giving you the checklist. I'll put it in the chat, and I'll also put it in the WhatsApp group. Read, there's no problem. We don't start with the problem tomorrow. Tomorrow we start with the checklist. Imagine that you are a mediator and prepare a mediation opening statement for a mediator. You can imagine parties, but what we want is it to be a very personal statement of who you are, and how you will, what are the things that you will say to make the parties comfortable and to be able to trust you. So depending on which industry you come from, you imagine a matter that's come to you from that industry. You can name your parties if you wish, or you can identify your parties if you wish. So that's hypothetical. But you are the person that you are. So you please describe who, you say your name, where what is your expertise, what do you bring to the table, the ground rules that you want to set, whether you want to have the case online, whether you want to have the case in person. All of that is your decision and how you're going to word it. Tomorrow we will be joined by a senior mediator who will help us, who will listen to your opening statements, who will give you feedback on the opening statement that you write. And of course, there's nothing right and wrong. It's just about understanding what needs to be done. And who'll also explain to you some more tips and this thing as to how you can improve what needs to be said, what need not be said. So that's the format for tomorrow, and that's your homework if you can spare a few minutes to do that.
How many minutes? Any particular limit for this?
Around a maximum of 10 minutes per person.
Okay.
Okay, and this is mainly for the new batch, but if we have the time, we can take up a few of the refreshers also, because they've already done this exercise before. So it's going to be primarily the people who are attending it for the first time. It's for them.
So basically, it is the introduction part of the process of mediation, right?
Introduction, but introduction only by the mediator, not of the parties. Because that's the most important thing. All of you are learning to be mediators. So we want the statement to come from the mediator. So I'll just share the checklist with you.
Yeah,
So you
yeah.
will know what I'm talking about. I'm stopping the screen share.
Normally, the opening statement is for the parties, right?
Both. But main opening statement is for the mediator. I mean, what we learn to say is for the mediator. Parties are given a chance to express what their dispute is, but the mediator has to, the whole setting up of the ground rules, what the mediation process is, the fact that there is no conflict of interest, all of that is what the mediator does. So you build your base at that point of time.
Are you putting the checklist again, or you're sharing it on WhatsApp?
It's here. I've just put it. Okay, sorry, I shared
Okay.
the wrong one. 1 second. Let me put another one. Ignore the first one.
Can you put it on the WhatsApp group?
Yes, I'll put it on the WhatsApp also. This is just for you all to see what
Yeah.
the checklist is, in case that you all haven't. So the second document that I have pasted is the right one. It has CMC written on it. Yes, so those of you who it's 9:30, and those of you who'd like to leave the meeting are welcome to do so. If you all have questions, you all can wait back, and Ranjan is also going to share his perspective on the mandatory law part that we were discussing. There's also a note that Mrinalini will share with you in the WhatsApp group. So that will, in terms of explaining that. Yes.
So all these points you have to figure out, mediate opening statement checklist.
Yes. Yes. So I'll also
Next week.
send you the PPT, so you'll get some of that from
Ah.
there. Okay.
Invite.
We've covered it in today's session, and you'll get it there. And of course, if you struggle with something, you can ask us that tomorrow before the session, and you can add it in your opening statement as we go through it. So it's not like you have to have nobody's judging. There's no marks or anything. It's just a method of learning. And unless we do it, we don't learn. So that's the reason why we do it.
So there's no case scenario as such, right? It's just
No, in this case, there's no case scenario. Case scenario is coming
okay.
next.
So just
Case scenarios, that's next. This is so that we don't have any other angle. We are just focusing on how you want to be seen as a mediator.
I must say that was really quite interesting. Quite looking forward to learning more. So thank you for making it so interesting.
Thank you so much. And yes, discussions are very nice, very pertinent questions. Just enough questions for us to be on time. But thank you, lovely group, small but nice. We generally have larger groups. We have much larger groups, but a few people who had registered last minute said that this time is not suitable for them. But we had postponed this training already. So we didn't want to reschedule it again. So we said we'll go ahead with the numbers that we have, and it's okay. We can't keep waiting for everybody's convenience. So therefore we had eventually a very small group. And that's why we invited that, okay, other people can join in, because one of the challenges with this is we need a certain minimum number of people to be able to have our conversations and have our role plays, which we begin next week.
Madam, one just reminder, if that last session, if you can have it.
yeah.
Because I myself have a lecture on that day.
3 to 5, you said, no?
Yeah,
So,
3 to
yeah.
5 or
from
even
Mrinalini,
Yeah.
yes,
even 2
Mrinalini,
to 2 to
I put a
4
poll on
also,
it,
4:30 will also do for me. I have my lecture. I have to address one lecture at here.
at what time is your lecture, sir?
My lecture is at 5:30.
Okay.
So if
I'll just ask Mrinalini to put it on, put a poll on the chat in WhatsApp. And it's basically just the 6-7 of you who have to take a call.
Yes,
The rest
yes.
of them.
Out of 7, 2 are already confirming
Yes.
to it.
Yeah,
Yes.
yeah. I'm confirmed. Yeah.
Okay. Okay.
Thanks, madam.
Thank you.
I will quit for the day.
Yes. Yes. Rajan, you may go ahead.
No, on the point of confidentiality and duty
Yes.
to the public, in the sense that reporting to this. Number one, my submission is that as far as mediators are concerned, they are supposed to keep the confidentiality. So obviously, now I would like to give an example of a lawyer, criminal practicing lawyer. Many a times the criminals come and disclose that yes, I did the crime. But as a lawyer, he is duty bound. It becomes a privileged communication between him and his client. He cannot go and discuss to the judges that he has already come and confessed to me that, or he has admitted his guilt. So similarly, as far as even though there may, in fact, IPC there is an express provision that every citizen is expected to report to the police of any crime that may take place. Of course, for criminal matters, there is no mediation. So, even if in the course of the mediation, if a mediator or any lawyer, if he is especially a lawyer, or even if it is a doctor who is mediating as far as anything related to the medicine, because this particular course, if I have understood correctly, is for the doctors basically, that how to resolve the dispute between the patients or their relatives and the hospitals or the individual doctors. There also the question arises is about the confidentiality, because they are also bound to keep confidential things. So even if a association or any mediation is taking place before any doctor panel, assuming that it is health related, I think still they are duty bound not to disclose anything to any authority, including police, because it becomes a privileged communication. That is what I
Okay.
wanted to.
Yes, thank you. So this is a matter that gets debated everywhere, and some mediators have a very strong stand that everything is privileged, and some mediators have a very strong stand that in certain cases they will be they have a duty to disclose, and that is exactly why we mentioned it to be part of the opening statement, that if you feel that there is an obligation of such a nature, disclose it in the beginning, so the parties are aware that this is your stand. For example, a lot of people do not want to have any kind of and this right from my first training, the first training I conducted, even the training I took part in, this matter is debated a lot, because what we say is law makes this communication privileged. Are there exceptions or not? In the US, there are specific exceptions for children. In India, it's not covered under the mediation law as yet. There is a separate law which says that this is a provision and all citizens are duty bound. It's beyond the exceptions that are given in the criminal procedure. But it's again a personal choice. And when you are making that personal choice, Rajan is exactly correct that if you have not disclosed it, that this is your personal choice to the party before the party shared it with you, you have no right to go and breach that confidentiality. Which is why that comes in your opening statement, that if you have any such obligations or any such ethics that you have put for yourself and you want to abide by them, please disclose it. Am I correct, Rajan?
But what is the point of asking them to disclose it? That like you will not take up mediation for them? That it goes
No,
against
it's
your
not like
ethics and
that.
values?
It's not like that. It's basically saying that if any such information is brought out, I have an obligation to protect the vulnerable. I have an obligation to disclose it or to complain against it, or to raise an awareness about it, to make it known to the police like a whistleblower. And therefore, please be informed that this is an exception to the confidentiality clause that I am committing to.
So basically, you're asking the parties whether they are, child abusers, or they are rapists, or
We
they
are
are
not
murderers.
asking them to disclose. We are saying that if such a matter comes to my knowledge during the process, I am duty bound to
disclose.
So basically, what you're doing is you're giving them a blanket confidentiality provision. You're giving them that privilege that Rajan is talking about. That anything and everything that you speak of over here is confidential. I will not disclose. Except 1, 2, 3. So what are those 1, 2, 3 for you as an individual? Because every mediator will have his own ethics. Define your ethics, and to whatever extent that you can have. What you can't do is, if you haven't disclosed your ethics, you haven't put it out specifically, you come to know something, you cannot breach the confidentiality. That is doing wrong to the party, because you are breaching their confidence that they have kept in you. They have trusted you to come to you that whatever you tell them is confidential unless there is, and confidential outside that space, confidential within that private space. If you're going outside that space and disclosing it to an authority, to a third person, whatever it is, because you want to protect another person, that is a breach of your obligation towards that party. If you have any such ethics, please put it out there right in the beginning. Don't do it. Otherwise, what you're doing is you are breaching their trust. That's not
But
good.
how do you kind of say it to them, like you'll sugarcoat it and say it to them that everything will be confidential, except if I come to learn that, in the course
Except anything that comes under POCSO. And so basically we were discussing POCSO because
POCSO.
yes.
No, but what if I don't want to deal with murderers and rapists and terrorists? Then what do I do?
Then
Tell
you
them
can,
all about it?
yeah, tell them that,
But how do I tell them that if I come to know that you are a terrorist, a rapist like that, I talk to them?
no, you don't talk to them that
Exactly. So
you
how
are.
do I?
You are. So you say that as my personal ethics, because this is not an obligation under the law.
I know, but
So
yeah.
my personal ethics. So if your personal ethics, so I have no issue with dealing with people who may have a criminal history, as long as I'm not, I'm not dealing with that issue in per se. But if you have a personal thing that ethics that you will not deal with certain people or certain matters, you can specifically say that anything that happens here is confidential, with the exception that now again, just because somebody tells you something in a mediation, you don't have an obligation to disclose it. What you have the option of is to recuse yourself from the case, except where it is mandated under the law. And the other matters are not mandated under the law. What you're talking about, murder, terrorism, is not mandated under the law. So you can excuse yourself from the matter and say, this is not a matter I'm dealing with.
What is the meaning of mandated?
That means the
again?
law requires you as a citizen to inform the police in case you know of certain facts about such things.
So it's not mandated.
Nothing else is mandated. You know about terrorist activity, you are not an agent to go and tell anybody.
So, it's like our infectious disease one, the polio and that stuff, which has to be, has to be informed to the BMC. There are
Okay.
some things which are under
Yes.
the governance where you have to do it.
You have to do it.
If
It's
you
mandated.
come across it.
Okay.
Similar to that.
Me as
So
a
POCSO is
doctor,
the only thing. POCSO is the only thing which you have to report.
As far as general law is concerned, it's only that. Now, as a doctor, you might have many things, which I'm not
If
aware.
you,
see, as a doctor
if and
under
when,
CRPC, for my practice in an ER, I have a obligation under Criminal Procedure Code 39 that anything which is medical legal, I am bound to inform to police. And if I don't, under IPC 172/226 something, they can even arrest me. So then in mediation, does that apply to me?
if you see the Mediation Act, which is yet to be implemented, Section 23(2), I put it on the chat, which says there shall be no privilege or confidentiality that will attach to a threat or statement of a plan to commit an offense punishable under any law for the time being in force. So there's a specific clause which says that there will be no privilege of confidentiality.
So there is no privilege of confidentiality for domestic violence or child abuse. Statement made during mediation showing a significant imminent threat to public health or safety.
Right. So specifically
So
mentioned that.
So that is all coming under this clause that is mandated under the law.
So all this has to be reported, it means.
These are not privileged under the Mediation Act, is what the Mediation Act is saying. So Sudhir, Dr. Sudhir has basically shared that these are exceptions.
Dr. Subodh.
Sorry, Dr. Subodh has just shared that there is no privilege of confidential that will attach to these three things. Yes,
My
Kamakshi.
point, sorry, my point was on slightly on a different thing. because
Yes.
criminal matters are not allowed to be mediated.
Correct.
So anything that will be considered to be a crime,
No,
that can never be a part of any mediation.
No, I
That
think
is
the
one thing.
point here is if at the point of discussion, say matrimonial dispute or whatever you are dealing with, if a point comes that I'm contemplating a separation or a divorce because this guy tends to be having a
Tendency
affection
of
for children, and then he tries to do something like this. So you have learned this that he's done
Yes.
something to his neighbor, and that's the reason you are going for a divorce. So if you learn of a fact which is maybe not very directly related to the case in hand, but it's incidental. So they happen to tell you because you're given that kind of rapport, assurance that confidentiality will be maintained. But you will have to tell them that upfront that that may not be so. Where it's an offense, my privilege ends there. I mean, confidentially will have to end there. We'll have
I
to.
agree with Dr. Saab on that point. That okay, if it is related to anything offense, that will be considered to be an exception to the entire mediation process. Because as a mediator, we are not expected even to be a witness in any court proceeding.
Correct.
Now there the word is any court proceeding. So the questions related to admission or a confession of a particular nature of habit, I should say, that he is having affection or he is doing something which is unnatural, I should say. In that circumstances also, when you are not expected to be a witness also, or to give any sort of evidence related to any even in any criminal matter, then why do see the question is that if by any chance any mediator will go and disclose it to police, because under IPC also it is an offense if you suppress certain information which will lead to any offense.
I'll
or
tell you the
which-
difference between that and between what we spoke about and what you are talking about, Rajan. There is no duty of here. There is no privilege of confidentiality. That is different. Where there is duty of disclosure is different. They're two different things. Duty of disclosure is where the law mandates that you need to disclose. That means
but
if you don't
when
disclose, you are
IPC
at
when IPC has declared that it is an offense to suppress information related to any criminal, or because there is another provision.
You are not suppressing information. If suppressing information is when you learn about something, the police asks you and you don't share. You don't have a duty to go out of your way and make a criminal complaint कि मैंने सुना है कि उसका वो अपनी बीवी का मर्डर करने वाला है. You don't have a duty like that. You have a duty only in case there is a child sexual offense or probability of offense to a child or sexual offense to a child. Yes, Kamakshi.
There are two things that I just wanted to say. The first one, of course, is regarding the issue that we are discussing with regard to disclosing and non-disclosing of information. So even for the information that has been put up in the chat, this is all, from my understanding, what the Act says, that you are not bound by, or rather, there is no privilege of confidentiality that is offered. It doesn't necessarily mean that you're expected to go and report these matters. POCSO as a law mandates you to report the matter, unlike, for example, domestic violence, which is a right of an individual to make that choice. And you have no right to go and say, oh, there's domestic violence happening in somebody else's house. That's not your problem. But in the event you are questioned, as somebody who may have that information, at that point of time, according to this law, you may be required to disclose that information. So that is the first aspect. As far as criminal law is concerned, I think Allah's kind of explained it pretty well. That in the event, again, there is an investigation and you're asked a question that are you aware of such and such act? For example, if there's a murder or something of that sort, you may still take the plea that I do have some sort of information, but I'm bound by this confidentiality. And then it can be explored of whether you need to disclose it or don't need to disclose it. That's a different issue altogether. Another point I wanted to make was something that Dr. Sudhir Rai raised, and he said, as a doctor, I'm expected to disclose certain information. Now, that information you're expected to disclose as a doctor, because you have that information firsthand. You may not necessarily be expected to disclose that information when you are a mediator. Because as a mediator, you're protected again under the same laws, because you're not really dealing with the patient, but you're dealing with the issues that the patient is having, probably with the doctor or the institution or at whatever level.
And you're not part of that institution.
So
You
you're
are a neutral third party.
So
in
you're
that
dealing,
case.
yes. So in that case, you're dealing only as probably a neutral, as a mediator, and that's your role, and not so much as that of a doctor. So there are just two things that I wanted to sort of comment on. Thank you.
Thank you, Kamakshi. I think Vishwanath had something to say, and that's the last one. And we need to end the session.
I mean, what we are discussing is something the criminal nature comes up during the process, mediation process. So as such, criminal is not admissible in the mediation, but you are coming to know during the process that there is an angle of criminalization on this particular case. So obviously it is A, you have an option to quit that mediation, and B, as a mediator, what is your duty bound is supposed
So that's not what we are discussing. What we are discussing is how we have not reached that stage of communication and problem solving. We have not reached there. We are still at the opening statement level. So in the opening statement, there was a small clause which said that if something is mandated by the law, that means disclosure of something is mandated by the law. Current law, only one act is mandated. That is against sexual abuse of children. Okay. So only if you have any information relating to an offense of that nature, you have a mandatory obligation to report it. No other thing is mandatory. Whether you are a mediator, whether you are a lawyer, whether you are anything, you are mandated to disclose that information. Except for if the offender is come to you as a lawyer, then you have a duty of privilege towards that person. But that obligation or that privilege does not apply to that mediator. And if it does not apply to you, you have a duty to disclose it to your participants, to your parties, so that they are not taken by surprise that tomorrow if something comes out in the communication and you go and complain against it, you can't tell them later, no, I have this, it's mandatory for me to do it later. If it has to be disclosed, they need to know about it when the matter is starting. So you may even make a simple statement like any offense that requires reporting to the authorities, that makes reporting to the authorities mandatory, I have an obligation to report it. Even a statement like that, because ignorance of the law is not an excuse. Everyone should know that this offense is to be reported. So you don't have to go on and explain what offense, why, and all. So if the law requires any offenses that are that need to be reported, I will not have the privilege to protect you in confidentiality about that. Even a statement like that, if you feel that you need to do it. Now, again, I gave that small qualification that depending on your case, if it's a commercial matter, there is nothing involved, you don't need to bring that clause into the picture. because there is no such reporting that's required.
No, even there it is possible in a commercial dispute. Somebody may say कि अगर ये settlement में नहीं होता है तो मैं इनका property को ये कर दूंगा, destroy कर दूंगा या इनको उड़ा दूंगा. You know, some people may
Yes.
just tell you that. So
Yes.
if you discover that and if there's a significant imminent threat to public health or safety, then you need to say that, right?
So here is what we are telling you the difference is. There is no privilege of confidentiality. There's a big difference between duty to disclose and privilege of confidentiality. They're two different things. Duty to disclose means it makes it mandatory for you to disclose under the law. There's a punishment if you don't disclose. Privilege of confidentiality is you are stopped from disclosing. Even if you know, you cannot disclose. What this clause does is just takes off that privilege. So if a police comes and questions you, are you aware that there is, that this woman is being beaten up? You can disclose that she's been beaten up. That's the privilege that they're removing. But you don't have a duty to go to the police. Aaj mujhe pata chala, tomorrow I go to the police and say, I'm a mediator in that case, and that lady is being beaten up by her husband. That's not your job. So that is a big difference in the two. And that is why disclosing it is necessary, because this is coming under the Mediation Act. This everybody will know, whoever is coming for mediation. But that is something beyond, and that's the only thing. And in matters which you don't feel, there are no children involved, there's nothing, you may not say it at that point of time. If you feel at some point also, disclaimers of this nature can be given at different stages also. You don't have to say it everything right in the beginning. Okay.
There are two cases. One is an allegation. See, allegations come at any stage of proceedings. So is it the case that when you get an allegation, you have to intimate? So certainly it will not.
No.
You know that it is the truth. The truth comes when you conclude that yes, there is a criminal
Even
handling.
if there is a truth, Vishwana, we are not talking about the truth. We are talking about only one small obligation that is there under the law, only specific with respect to child abuse, and that too only child sexual abuse,
So
not any child abuse.
okay, means
Very small, and that is a duty of disclosure. That is not an obligation of any other nature. You are not supposed to go and fight for it. You are just, even a phone call to the child helpline or to the child, there's a child unit in every police station. Even a phone call to that saying that, this is a thing I know about, please take necessary steps is enough. That puts an end to your thing. You are not supposed to do anything else.
it is know about it or allegation. There is a
Know about it. I'm very clear. Information. Just having information about that.
It can be allegation.
No allegation. There is no need to be an allegation. It's just knowledge, your knowledge. Allegations and all that, we'll handle that as we go ahead. It comes up in every mediation. There are threats, there are, threats, then there are allegations, there are bad words. All that comes up in every mediation. Let us handle it separately. What we are talking about here is only something that you disclose in the beginning, in the opening statement. It's not something extraordinary.
Okay, means you in an opening statement, you have to categorically specify that, okay, these are the two offenses where I am bound to inform to the authorities.
You have to say that anything that is mandating duty of disclosure, I will be bound to disclose. Okay.
May I put it like this? May I put it like this?
Of the participants will be, what are those?
Then you explain. Then you explain it to them. But when you are explaining to them, please understand what it is so that you don't confuse the parties and you don't scare them. So that's why when we are putting that clause, be in a position to explain what you're talking about. If not, leave it out for now, study it properly, and then disclose it.
But I'm a little worried
Sir,
about being misused also. Yes, ma'am. Fine. I said there's a small chance of it being misused also by the parties, because at least in medical cases we have come across these situations where they're pretty smart. So in case you come up with a clause like that in the beginning, it can also be misused.
Yes,
So
so
that
then
also we
again-
would be very careful.
So what we can do, if you feel like that, what you need to be aware of is that what we are giving you now is setting the stage. You need not do it right in the beginning. You see how it's going. Let the opening statements of both parties go on. And somewhere where you find that, okay, now this is, a lot of information is coming out here, particularly in the private session, that's the time you can disclose it to them, saying that, I'm letting you know that certain disclosures I'm mandated to report under the law, and this is how I'm just letting you know that this is my obligation. Please be aware of it. Other than that, everything that you say here is confidential.
what I feel is that if we make a statement like this, that under the Constitution of India, there is an Article 51A, Clause I, to safeguard public property and to abjure violence. One of the duty that has been cast, it's a Constitution of India says so. So if we make a statement to that
Yes.
effect, that as a mediator, I am bound by the Constitution of India and under Article 51A, Clause I am supposed to report related to anything related to the public property and abjure violence. I think that would cover. Then there is no question about any privilege and non-privilege, or whether disclosure or
Yeah.
I mean whether
That's-
specific.
So
But that's
again,
what Dr. Subodh has put up, na? Statements made during a mediation showing a significant imminent threat to public health and safety. The same thing.
Yes. No, but then
Yeah.
we can.
so this is the act. This is the mediation act that he's extracted. It's
No, I'm Constitution of India.
yes. What Rajan is talking about, the Constitution of India. What Dr. Subodh has extracted is from the Mediation Act. So it's up to you. If you want to leave that out when you're practicing your opening statement, please feel free to do it. We are not counting as to what you are disclosing, what are the points that you're covering. We are going to be looking at your body language, the tone of your voice. We are going to look at what are you creating in terms of a safe space, what are you doing to build trust. Those are the things that we're looking for, and the personal element that you're bringing into the picture. So let's focus on that. This is a small thing. You may add it, you may delete it. Let's not lose the whole plot because of this one clause. Let's stick to it, because there's a lot more to mediation than this one little clause. Okay. Thank you so much.
Good night.
Wonderful
Thank you
discussion.
and good night.
Good night, ma'am.
Good.
Good night. Good night. Thank you.